Hello everyone. Thank you so much, Patricia, and welcome to today's webinar on child-related relief in the context of civil protection orders. We're going to look at challenges and opportunities for improvement. My name is Darren Mitchell, and I am an attorney and a consultant to our host, the National Council of Juvenile and Family Court Judges. I work in the areas of domestic violence and civil protection orders, family law, especially custody decision-making where there's domestic violence, and on domestic violence and firearms. I am joined today by a friend and colleague who I'll have introduce herself before we jump in.
Good morning. This is Mary Madden. I am a family court referee in the 4th Judicial District in Minnesota, excuse me, which is in Minneapolis and encompasses all of Hennepin County. I will just give you a little bit more information on my position as a referee because I think that position differs around the country depending on location. There are 15 judicial officers in my district on family court. There are 9 judges and 6 referees. While there are some differences between judges and referees, there really aren't any differences for purposes of this webinar or for purposes of the work that we do. All of us handle the exact same caseload, types of cases, numbers of cases, etc. I've been a referee for 11 years, and prior to that I practiced exclusively family law for about 20 years. My district, the 4th Judicial District in Minnesota, has been lucky enough to receive now 3 grants from OVW to do work on domestic violence in the area of family law and outside of that. So thank you for joining us today.
Great. Thank you so much, Mary. So we'll jump in, and first I want to thank the Office on Violence Against Women at the U.S. Department of Justice, who has sponsored, funded, and assisted with this work that we've done for many, many years around civil protection orders. And of course, we learned over the course of that work with communities around the country that few challenges were more vexing than trying to increase the availability of child-related relief in civil protection orders. And there are lots of differences in how communities across the country, jurisdictions across the country approach the issue. There are differences in, of course, statutory authority that's available around kids in civil protection orders, and we're going to touch on all of those things. But as I mentioned earlier, we're really going to be spending some time thinking about what the challenges are and some potential solutions and opportunities to improve the system. And we're going to start off by finding out, well, let me give you the learning objectives first, I'm sorry. So our goal here is that as a result of the webinar, you'll be better able to recognize significant obstacles that exist to including effective child-related relief in civil protection orders. You'll learn about a set of suggested practices that you would include in an effective civil protection order process that would address child-related relief. How to use some practices to both assess and enhance your own processes and decision-making regarding child-related relief. So you'll have an opportunity to sort of gauge what you're doing against some of these suggested practices. Now we'd love for you, we have a relatively small and intimate group, which is great, so we definitely want to make this and kind of adapt it to your needs. So I'm going to strongly encourage you to chat in if you have any questions or want to make any observations along the course of this. We can certainly customize it to what you're facing in your own communities. But to start us off, if you wouldn't mind chatting in your name, your professional role, and where you're located so we have a sense of who's on the phone with us. Thank you so much. Thank you so much for chatting in. We have Nebraska represented on the call. And you heard that Mary is located in Hennepin County in Minnesota. I am calling in from just outside of Washington, D.C. in Tacoma Park, Maryland. Thank you, Judge. We have Decatur, Georgia. It doesn't look like anyone else is chatting in right now, but if someone does, we'll mention it. So much of what we're talking about today is found, at least in summary form, in this document that I put up called Custody and Visitation in Civil Protection Orders, Guiding Principles and Suggested Practices for Courts and Communities. This document is available on the ncjfcj.org website, and Jennifer just typed in the link to the document. This was a set of principles and practices that were developed, sort of compiled and developed by an interdisciplinary national group of folks who work in this area. The document reflects the thinking and some practices of folks from all over the country in this area, and provides some principles and practices that courts, especially, and also non-court stakeholders, can think about putting in place in their own communities in order to get more information about the child-related needs of petitioners in civil protection order cases, how judges can issue effective relief that's tailored to the families, the relationship between civil protection orders and other family law cases, enforcement of orders, and many other aspects of the system. We will be going into touching upon just about all the different areas covered in the document in a little bit more detail. Plus, Mary's going to share insights from her work in Hennepin County on this issue. So a lot of what you hear about you can check out in the guide, and if you have any follow-up questions, of course, after reading it, you can reach out to the National Council. The contact information is part of the document as well. And I just want to mention that we have Kansas City, Missouri as well on the line. Welcome, and thanks for joining us. So a brief overview. For those of you who have been focused on practice in your own area, I wanted to give you a sense of kind of what's out there nationally, because there are significant differences in many ways. But generally speaking, in all but the District of Columbia, in all but 4 states, DC does have this, in all but 4 states, there is some form of temporary custody parenting time available as part of the civil protection order process. There are 4 states where if you want any sort of child-related relief beyond no contact, you have to go to another process outside of the civil protection order process. The standards that are used and all kinds of things differ, but it's available throughout the country. In addition, there are often questions about the relationship between parenting time or custody visitation arrangements in a civil protection order and what is available or becomes the case in a particular family as part of a long-term custody or visitation order. The relationship between the civil protection order, child relief, and that available in a longer-term order differs by state. In some instances, it's clear that one trumps the other. Sometimes a civil protection order determination can trump a long-term order, at least for the duration of the civil protection order. In other instances, it's the vice versa of that. And some statutes are completely silent about the relationship between the two. This is an area that's caused a lot of confusion in many places around the country, and we'll have a little bit to say about that as well. You probably know that although at this point still I'd say the majority of statutes refer to custody when they're talking about this form of relief, there are lots of other terms that have arisen over the course of the years. Temporary parental rights and responsibilities, care and control, possession of the child, legal and or temporary physical care and possession, residential custody. Some of these terms, of course, are borrowed from longer-term custody decision-making. And statutes often refer to visitation, but sometimes you see it described as parenting time, right of contact, or access to the child. So if you're looking at your own statutes and trying to figure out what the law is, what's available, you may see these other terms, which sometimes cause confusion amongst folks, especially as orders travel from one jurisdiction to another. So, go ahead, Mary.
Go ahead, Darren. I didn't mean to cut you off.
No, I was going to say, I'm going to turn it over to Mary to ask a first question we have for you all.
So we're going to talk a lot about why are we doing this? Why in a civil protective order would we address custody and other child-related relief? as part of that process. So would it, if the people who are participating in the webinar would just take a minute or two to type in the chat your thoughts on why would we include this? Why would we want to include these provisions as part of a civil protective order? I see people typing, so we'll just wait and see your thoughts. I think people have finished typing. If you want to add anything more, anybody else wants to jump in, please feel free to do that. And the responses that have been typed in are exactly what we share in terms of shared purposes around the country, in terms of what both the statute provides and the kind of work that we do. So we've got the long and short-term effects on children of domestic violence exposure. And I think one of the answers was, the responses was that the protective order is for an emergency purposes, and it allows the petitioner time to protect their children while figuring out a permanent solution. So that certainly does address the concerns about both the long and the short-term effects of domestic violence exposure on children. We've got a response that includes number 2, where a perpetrator's use of kids can be both, the kids can be used both as a tool and a pawn to manipulate the petitioner, create added risk of harm, and using the civil protective order or addressing civil protective, the custody and parenting time provisions in civil protective order can help put that at bay. There is an increased risk, as we know, at separation when a victim attempts to terminate the relationship or leave the relationship to seek protection. We also want to provide overall for the children's safety and well-being, and not only for the petitioner but the children. And if we do not address that in our civil protective orders and victims are not assured that their children are going to be safe, it's unlikely that they will seek relief from the court. There's also the larger issue of providing safety in the community. If we don't address custody and parenting time issues, we can potentially have free-for-all, for lack of a better word. We've got exchanges that may happen or communications that may happen about parenting time and exchanges occurring at a homestead. So there can be an incident of violence that affects neighbors. We can have a respondent arriving at the school because he or she wants to see the children and can't see them any other place. So it creates a risk of harm for the larger educational community. We got the same situation at workplaces where there's a disagreement about parenting time. And so somebody shows up at a workplace in an effort to get parenting time or address the issue of parenting time. And lastly, it also allows us to confirm the victim parent's parental authority and provide, as a court and a community, provide support for the victim's parental role and setting boundaries for safe contact between the children and the perpetrator, if that's appropriate. And we'll talk more about the appropriateness of parenting time in situations where that may be appropriate and others where it may not be. So I will turn it over to Darren.
Thank you. And so part of what we're doing here and what the guiding principles and suggested practices document does is lay out the case for why you would want to address these child-related relief matters as part of a temporary order when, in fact, there is an opportunity to get a long-term order in most instances from the same court or from a court elsewhere in the community. And just to sorry, went too far there. Let you know some ideas around support or research that supports what you all said and what Mary just talked about. The National Council has put together a guide to research and also resources to assist with, around children's exposure to domestic violence, which lays out some important research-based findings around kids, including their resilience and what factors contribute to resilience. Well, these are 4 really important resilience factors: that there be continued care by a primary caretaker, who in many instances, in most instances, is the abused parent; that there be stability in the home and beyond the home in the school and community; that overall the child becomes free of a violent environment; and that counseling and other supports are available for the children. Well, we know that well-crafted civil protection orders can actually address all 4 of those resilience factors. And that's part of the reason we think it's so important for orders that are issued by the court, even temporary orders, to address kids and kid issues. So take a look at the document and you'll see more and more of the reasons why we think it's important. But we'd also like to ask you now and shift a little bit into, if it's so important, and many people do recognize that, why are custody and visitation provisions in civil protection orders often not available to petitioners, even where the relief is appropriate, the petitioner is eligible for the relief, it was requested, and it's necessary to protect children and parents. But we know so often from working with the field that these kinds of orders or judges sometimes are unwilling to address child issues as part of civil protection orders, except sometimes to say no contact with the child. Would you all please type in reasons why either you've experienced or you know of where this kind of relief is not available to petitioners who are eligible for it and have requested it? So we have one person typing, and we'll wait and see what her observations are on this issue. And just to let you know a little bit of background, we've been working on this issue of civil protection orders and child-related relief for many, many years in many different communities. And a lot of what we'll talk about today are based on things that we've seen and some themes that have emerged in doing that work. And I can tell you from the perspective of the group that met, the multidisciplinary team that met to develop the guide that I showed you earlier, the general perception was that custody and visitation were not adequately addressed in civil protection orders virtually everywhere in the country. There are certainly some exceptions to that, but as a field, I think we've recognized that in part because these types of orders are available elsewhere and civil protection order judges don't have the time to address the issue, they're not addressing it as part of orders. So I'm going to jump in, and someone's still typing, but I'm going to talk about some of the challenges that we've seen and that the group talked about in developing our guide. So one is, and we've already tried to address this a little bit, is that there are folks in the system, judges and others, who don't really understand or recognize how abuse can affect kids, and also how abuse affects parenting, especially the parenting ability of the abused parent. And so continual education around the impact of child exposure to domestic violence, even if the child is not directly physically abused or sexually abused, the impact there that needs to be addressed. And as I mentioned earlier, in a handful of jurisdictions, there is no authority to do so. In some cases, it's a perceived lack of authority when there actually is authority. But there are a couple of places where you cannot issue these kinds of orders as part of civil protection orders. A big one is the fact that many people note, of course, that these cases can be complicated. Both parents sometimes present with concerns, areas of concern and challenges to their parenting. Sometimes the evidence of the abuse, and especially its impact on the kids, is not there or not well developed. So there's a lack of information, there's a lack of time, it's hard to make the appropriate findings, and it's hard to ferret out what's happening in the family in a civil protection order matter in the course of a short hearing. So we'll come back to that in a little bit, but that's certainly a huge reason that folks point to. Many times the petitioner doesn't know that child-related relief is available, and sometimes they don't ask for it purposely. They don't want the kids to be part of the order. So both of those things can be happening sometimes. We know that the vast majority of folks throughout the country in civil protection order cases are self-represented, and the numbers in places that have looked carefully have seen that the family court context, and especially the civil protection order context, is the one civil procedure where the lack of representation is at its strongest. In some courts have seen greater than 95% of litigants involved in civil protection order cases being unrepresented by an attorney. And so, of course, that dramatically affects the ability of folks that seek and support requests for child-related relief. And one of our participants said that she's stumped just because our bubble domestic violence protection orders have a 90-day temporary custody option for the petitioner. I was told it was because if they want them protected, to add them as a petitioner. Otherwise, they need to go to family court for custody issues. So it sounds like in this particular area, although there is explicit authority to include at least temporary custody as part of the civil protection order, you have to add the child as a protected party or a petitioner. If you want anything other than that, maybe you even want some visitation for the abusive parent under restricted circumstances, which we know some victims do request. But if you want anything other than adding the child as a protected party, you have to go to the family court and get a long-term order. So that's certainly an experience that we see elsewhere as well. Thank you for chatting that in. And that's related to this next challenge, which is really the belief that the civil protection order court is not the right place to deal with this, and judges are uncomfortable with making those decisions. Of course, many of you have probably already heard this leg up argument that you're gaming the system, that the only reason you're asking for custody as part of your civil protection order is that you know you're going to have a long-term custody case, and getting that finding and that order of temporary custody as part of the civil protection order is going to give you a leg up in the long-term custody case and a better chance of getting long-term custody, legal and physical custody of your children. And coupled to that is a relatively widespread belief that research has shown that parties often make false allegations of abuse to gain that advantage. So the civil protection order is not even justified in some of these cases. It was purely brought to get this leg up. Unmarried parents, and we won't say much about this except to say that to the extent that there is research on false allegations, it actually it disputes that. It disproves that finding, and in fact, where research has been done, mostly in the sexual abuse area, but also to some degree in the domestic violence area, that lying about it having happened is less of a problem than underreporting, and then folks not believing people who bring up these claims or not being able to prove the claims. There's also an issue around, in some places, unmarried parents. And so if you're seeking child-related relief and potentially some sort of parenting time for the for the parent who's not the mother, who's not the biological mother of the child, and paternity has not been established, courts lack jurisdiction over making those kinds of custody and visitation awards. If there's no voluntary acknowledgement of paternity or other way to establish paternity, you can't get that kind of relief. And there's some places where that's a clear bar. Other places have workarounds for that as well, and you may have experienced that in your community. So those are the main challenges that we see in here. It's consistent with what one of our participants here has experienced, and we're going to spend some time now, the rest of the time really, talking about how to overcome these types of challenges. And please do chat in anything else you want to add to that conversation around what's making it difficult to get child-related relief and civil protection orders. So how can we overcome those challenges and develop an effective system in which folks who are eligible for this kind of relief and need it to protect themselves and their children are able to get it? First of all, whose responsibility is it? We're happy to have a multidisciplinary audience today, and clearly it's everyone's responsibility. So we think that courts need to be part of these conversations as well as their staff and court-based programs that assist victims and also, in some instances, provide information to and help respondents. Community-based programs, whether they're advocacy or social services programs, have a role to play in all of this, and other stakeholders in the justice system. We think that folks need to come together in a collaborative way and try to figure out what's going on in their system, what needs to be done to improve access to child-related relief for petitioners. That's exactly what we did as part of the Family Court Enhancement Project, which both Mary and I were part of, and our host, the National Council, was the lead agency on it. We're going to share some learning from that as well. But we did learn that it takes collaboration, it takes leadership, judicial leadership, of course, but leadership from others as well. There needs to be built in some accountability. Are people doing what they said they would do? And also evaluation. Is the change that we made something that actually resulted in an increased access to child-related relief? Or is there more that we have to do? Or were there some unintended consequences here? It's important to evaluate what's happened in response to changes you've made. Ideas around all of this are available in the guiding principles and suggested practices guide that I mentioned earlier. So turning now to the elements of an effective system, and this is what's going to form the framework for the rest of our presentation. We think that in order to have an effective civil protection order system around child-related relief, you need better access to emergency child-related relief. So you need to be able to get temporary emergency relief quickly. There needs to be better decision-making, certainly judicial decision-making, and to the extent that there are others involved, including in some instances mediators or GALs or others that may be making recommendations to the court, that decision-making accounts better for domestic violence, and we're going to talk about a framework for doing so in just a few minutes. We think judicial accountability is a key, and education. We think that enforcement is an important part of this conversation. So we think we need better enforcement of child-related relief. If someone violates those terms, in most instances, it doesn't subject the respondent to an arrest. So what can be done to put some teeth to these provisions? Education of all stakeholders, getting feedback from the community, from stakeholders, and making refinements to the system are all elements that we're going to spend at least some time talking about in terms of developing a more effective approach to civil protection orders and child-related relief. So we're going to start with that first one, better access. And what we'd like to say about this is we think it's critical, and that one of our participants on the phone talked about flexibility as being part of this. is that we think there should be multiple ways to access this kind of relief. And we think that if you're in a situation where you need protection, you should be able to go to the Civil Protection Order Court and get the protection you need, including child-related stuff. But you also need to be able to go to the long-term custody decision-making court, whether it's part of a custody case or a dissolution or divorce case, and get temporary custody and potentially visitation orders as part of that case. So one of the things we suggest to communities is to look at both of those processes. Are they both accessible to folks? We think that you have both systems. They need to communicate with each other to share information and avoid issuing contradictory orders. So it's important to develop some sort of coordination between your Civil Protection Order Court and the courts that are hearing longer-term cases, so that we understand how the CPO travels through the long-term court, that there's sharing of information in case some evidence comes in the Civil Protection Order Court that's going to affect the long-term decision-making. How can that information get to the right court? And how can courts ensure that, that both orders, if there are more than one, are consistent with each other? And we have ideas around how to do that, but it's important to sit down with the folks involved in your systems to figure out how to make that happen. And that was part of the work that we did with the Family Court Enhancement Project. We think that decision-making in this area on the part of litigants needs to be fully informed. So we want litigants to get information, whether it's online, whether it's as part of supplemental forms or information that travel with the petition, whether it is brochures or informational videos. We want litigants to become informed about how they can get temporary custody, what the relationship is between getting that temporary custody and any other court process that may be involved, including long-term custody decision-making, and even better, providing litigants with information about what the court's going to be looking for in order to make a finding that you are eligible for child-related relief. What are the legal standards? Is the court employing a best interest standard? Is it employing a different safety standard? That information should be provided to litigants so when they ask for this relief, they can make their best case. We also suggest that you think about specialized or integrated domestic violence courts or dockets. The idea of one court, one judge, one family is especially helpful in the area of child-related relief, where you may have civil protection orders, long-term custody, and even criminal cases going on, and possibly child protection cases going on with the family. So all of those are important things to think about. It's kind of a checklist as you're thinking about your systems and how you may want to improve them. I'm going to turn it over to Mary now to talk about the decision-making side of things.
So achieving an effective system includes making improved decision-making that better accounts for domestic violence. All of the challenges that Darren talked about, we experienced here in my district. It is everyone's responsibility. It is a multidisciplinary effort, and it does require leadership and accountability. So what does improved decision-making that better accounts for domestic violence mean, and how do you do it? So I'm talking primarily from the judicial officer perspective, because that's obviously my role. But to get safer and more effective child-related relief in civil protective orders, we need to provide better support for litigants, especially those who are self-represented. We see, and I'm sure many of you who are on the phone in other districts, see an enormous number, and probably the majority of litigants who are self-represented, trying to navigate the system, either as a petitioner or a respondent, is challenging. So how do we provide that support? We need to get better and provide better information to the court so the court can make the proper decision. Information about, if you're talking about custody and parenting time issues and financial support, the details of employment, the details of schedules, the details about the children, their lives, their schedules, their activities. So getting that information to the court, and the court's responsibility to make decisions that account for the nature and context of the domestic violence, as well as the impact of the abuse on the children and how it impacts the parenting of both the victim parent and the perpetrator parent. With respect to better support for litigants, we in our district have something called the Domestic Abuse Service Center. Some of you probably have a similar facility. It's a kind of a one-stop shop where parties can obtain information about obtaining a civil protective order. There are advocates housed there, law enforcement, child protection, a variety of interdisciplinary community agencies are housed there, where a petitioner can go and obtain information about both safety and getting child-related relief in civil protective orders. We do provide in-court support. We recently hired what we call a resource coordinator. Other districts use a similar position referred to as a navigator, and that once you issue an order that has a variety of provisions, including perhaps supervised parenting time, and how do you find out where to do that and who provides that. If you order batter's intervention programming, where does someone go to obtain that? What's an appropriate program? So those are things that the court can refer people to, and we'll talk more about this in detail later on. And then information about other relevant community-based resources, housing, employment, mental health, chemical dependency resources, because all of those are ancillary issues that are intricately woven into the whole issue of domestic violence. So how do you get that information? Especially if you are the court and you can't go out and gather the information yourself necessarily, how do you get that information or provide parties with that information? Getting better information to support decision making, one of the things that we did, we developed, and again I'll talk more about this in detail, but providing victims of domestic violence with access to domestic violence advocacy services, legal advice, and legal representation. So it's important to make advocates available. It's obviously more challenging. The more rural the area, the more challenging that can be. But there are ways to do that, and we'll talk more about that later on. Legal advice and legal representation, whether it's civil legal services, a volunteer lawyers program, providing that information, we have seen a significant increase in satisfied petitioners when they have the access to legal advice and or legal representation. We, in Hennepin County, we partnered with one of our local legal services providers who agreed to appear on our civil protective order calendars and be available for any victim who wanted to talk with, consult with, or seek representation. And it eventually grew into, now they have a full-time staff person at our Domestic Abuse Service Center so that victims can have access to legal advice and or legal representation much sooner in the process than at the time of the hearing. And lastly, all of these decisions, whether they are regarding custody, parenting time, and all of the pieces of that, which can be very time-consuming but yet very important to detail out in an order, need to account for the nature, context, and effect on children and parenting by both parents. And one of the tremendous tools for us, and I would encourage anyone on the phone, whether it's civil protective orders, family court matters, anything that involves the issue of domestic violence, is the Battered Women's Justice Project, bwjp.org website is just a wealth of information. Specifically, what's informed our work and continues to inform our work is their SAFER project and their SAFER approach, which Darren will talk about.
Thank you, Mary. And I just wanted to mention before I dive into SAFER, I just put a link to a document that was developed by the Center for Court Innovation, which focuses on helping self-represented litigants in domestic violence cases, provide some ideas for how to address some of the things that Mary just laid out in terms of especially information for folks who are unrepresented, where they're involved in cases involving custody. So take a look at that document. It talks about some of the stuff that we've touched on as well and some strategies for ensuring that folks get the information they need to seek this relief effectively from courts. SAFER. So SAFER is a way of thinking about and responding to domestic violence in cases where you're making custody decisions. It can be civil protection order cases, it can be longer-term custody cases, it can be child welfare matters, it can be judges who potentially can use it, advocates, attorneys, guardians ad litem, custody evaluators, you name it. All stakeholders are making some sort of decision, some sort of response to domestic violence or intimate partner violence. This is a framework for helping you think through what's going on in the case and how best to respond to it. And in our context, the civil protection order context, this four-step process really kind of boils down to three, because you don't have to do the initial screen for intimate partner violence. Someone has now sought the relief of the court on that basis. Of course, the court has to make a decision as to whether it actually happened. But really, you're involved not in this first step as to whether is abuse an issue, but you jump to the second step, which is to take a close look at the nature and the context of the intimate partner violence, which means what's actually going on in this case, who is doing what to whom, what actions, behaviors are occurring. Is it physical abuse alone? Is it some physical abuse but also coercive controlling abuse? Are the children being abused directly? Are they witnessing the abuse? Are they intervening in the abuse? Are they witnessing the aftermath of the abuse? Those are the kinds of questions you ask about what's happening in this particular case regarding the abuse and who's being affected by it. Then, once you have a sense of who's doing what to whom, you start to look at the effects of that violence. You don't jump right from the fact that you've discovered that there's some abuse going on and you have an understanding of who's doing what to whom to what is my response. Instead, you spend some time thinking about what is the impact of those actions. What are the effects? And that means the effects on parents. It means the effects on children. It means the effects on parenting by both the abusive parent and the abused parent, to understand why does this abuse matter for these children. Once you've figured out the nature, context, and the effects, you're in a position to now tailor a response to that abuse that directly accounts for the nature and context and the effects of the abuse in whatever your job is, whether it's as an advocate to sort of advise someone about what they may want to do and seek in terms of relief from the court. You're an attorney who's in a position to actually advocate for the court to issue that order, that relief. You're an evaluator or a GAL who's making a recommendation to the court, or you're the court issuing an order, being responsive. What can be done about the abuse that you've learned about? So it's a four-step process that slows you down and gets you to understand that abuse looks different in all families and the impact of that abuse can look different, so the response needs to be tailored as well. We'll quickly show you an example of a tool that was developed by the Battered Women's Justice Project with a lot of help from the National Council and from others, including some judges who kind of field tested it. This is a tool that was aimed at enabling civil protection order court judges to put into practice that framework. And so what I'm showing you here focuses, I'll go back, on the assessing the nature and context and focusing on abuse. You see the colors correspond. There's a kind of khaki color, at least it's khaki to me, and orange color. The khaki color has to do, again, with nature and context. The orange color has to do with effects. And so this is sort of a note-keeping device. It's a way for judges to ensure that they're asking the right questions, looking for the right things. And you can see when we're talking about nature and context, we're trying to understand what the nature of the respondent's abuse of the petitioner is, what the respondent's interference may be with the petitioner beyond physical or emotional or economic abuse, what other forms of interference may there be, including over parenting and other related issues, what is going on in terms of the children's experience. Did they experience it during pregnancy? Is it direct observation or indirect observation, etc.? And finally, how is this affecting the parenting? And in this instance, the parenting of the abuser. There's also an opportunity to talk about the parenting of the abused parent, which is part of the third box and also part of what's going on below, which is now looking at the effects of the abuse. So how has this abuse affected the safety of the petitioner and the child? And you can see the guide has, many of you probably recognize these as lethality or dangerousness factors that research has shown indicates there's a higher likelihood of lethal or very serious violence and injury. And what's the impact on the petitioner and the children in terms of all those different domains, stability, both economically and housing and employment, mental health issues, what's it like, isolation, social, cultural ties, autonomous decision-making, is there any impact on the immigration concerns of the survivor, and then the child's behavior milestones on overall health, et cetera, et cetera. And there's also a box there to indicate what do you think the effect is on the parenting. Is it adversely affecting the abused parent's ability to care for the kids, to protect the kids, and to make their own decision-making regarding parenting of the child? So this is a way to use that four-step process for judges to kind of keep account of what's happening in a particular case, and then ultimately to use that information, going back again to the framework, to respond to what they've learned. And we're not showing you the backside of the tool, but it, which is written in purple, has a set of potential responses that can come as a result. And the idea is you tie your findings around the nature and context and the impact of the abuse to the relief that you order as part of the civil protection order. So are you going to order no contact, no access by the abusive parent? Are you in a position where you can order some visitation or parenting time for the abusive parent, but you want to put limitations on it? So are you going to use, if you have it, a safe visitation or or exchange program, supervised visitation or safe exchange program to do that? Are you going to include restrictions on communication between the parents to a particular time or format and only about the kids? Are you going to include economic relief? Are you going to include relief related to housing, health care, etc.? So the idea is you tie the abuse to certain forms of relief that are available as part of civil protection orders. So this is just kind of a brief taste of this tool and this approach, but certainly if you go to the Better Women's Justice Project website, which Mary just suggested is absolutely a source of incredible information. I just typed in their website. If you look up custody or SAFER on the website, you'll get to these materials, which include lots of other practitioners' tools, including interview guides and other things that you all as non-court stakeholders can use to support your work to help victims and children get child-related relief in civil protection order court. A couple of other things that we want to say that are present in that guide that I mentioned earlier around this, and that's visitation. So we know, and probably many of you have had the experience, that you can't assume that an abused parent wants no contact with the abuser. There may be many reasons why an abused parent may want some form of parenting time, and usually to have restrictions placed on it so that it's safe for both the petitioner, for the protected person, and for the children. So we think it's important to enable folks to get that relief if they want it, but to do it in the most tailored and safe way possible. So we think that courts should be addressing visitation in the civil protection orders if either party asks for it, and that you use the legal standard that's applicable. We think the legal standard is the court should be looking to decide in the first place, can visitation be safe? Look at the lethality factors. Look at the history. Can it be done safely? And if so, we can order it, but how do we put some protections in place so that it will be safe? we think that they need to be consistent with other orders, and so it's really important if there's an existing custody visitation provision in a long-term custody case, you need to look for consistency, or if there's a reason to not be consistent because of new abuse or whatever, to indicate that on your order, that your order is superseding because of the whatever's happened, and then ultimately the long-term court can make a decision on the basis with that information. We think that, of course, visitation terms should always be clear and specific. They shouldn't say things like, reasonable visitation, of course. I say of course, but we still see orders that say reasonable visitation. We think the judges need to specify, and therefore attorneys should be asking for specificity regarding the conditions for exchange, what the supervision is going to look like, if any, how contact and communication and whatever limitations should be on that, who's going to provide supervision, what happens if the party is late, how late, et cetera, et cetera. Plus providing information about if the order is being violated, how you can get relief as a parent. We also think that it's critical, and I know we have one person who does work who's on the phone, who does work around supervised visitation and safe exchange. So we're very happy that you're here. We think judges need to understand what's available in their community and what happens at these kinds of really important programs, and that they advocate for the creation of them if they're not available in their communities, and not to rely upon a law enforcement agency, a fire department, McDonald's, Burger King for exchanges, because clearly professional exchange programs are so much safer, so much more accountability and reliability. I'm going to turn it over to Mary, who's going to fill us in on some of the exciting happenings in Hennepin County around some of these areas that we've just talked about, and a couple of other things too.
Thanks, Darren. So when I first started at Hennepin County, I spent the first year or two trying to get a feel for the politics and the culture of the system I was working in, and became really distressed about how issues of domestic violence were being handled, specifically in civil protective orders. We have a very comprehensive domestic abuse statute in Minnesota that allows us to provide very extensive relief, but it was not happening for a variety of reasons that I'll talk about. But then came along this opportunity to apply for the Family Court Enhancement Project grant that Darren referred to. So we did that in 2012 and received the grant in 2013. So we identified 4 challenge areas that we wanted to address. And the first one, this challenge area one that's up, is that judicial officers and family court practitioners, and that includes attorneys, custody evaluators, guardians, anyone who touches a family court case, we're not handling custody and parenting time cases consistently with respect to identifying the domestic violence, assessing its nature and context, and then determining its implications for parenting. All of the stuff that Darren just talked about, and all of the stuff that is incorporated into that safer approach. So we had a lot of the challenges that Darren talked about earlier to improving our system. And for us, the big ones included judicial turnover. I referenced the fact that we had 9 judges and 6 referees in our family court system, and that's where we hear civil protective orders is in family court. And the referees stay for long periods of time, years, and so they have the expertise, the subject matter expertise, whereas our judges rotate in and out every 3 years. Many of our judges come to be appointed without any family law background. They spend 2 or 3 years getting familiar with their role being a judge, and come over to us primarily with criminal and other civil background. So we spent a lot of time, that's a big challenge, trying to train them not only on the subject matter expertise, but also all the nuances in managing civil protective order cases and domestic violence issues in general. Each judicial officer gets 2 law clerks, so that's 30, and added 30 people, and there's turnover amongst all of them. It's even more frequent than the judges. And then once we get judges to the point where they're comfortable with the subject matter and the decision making in family court and on domestic violence issues, then they're on their way out and we get a new one coming in. Judicial buy-in is a big one for us because was a big one for us, and we have calendars. When you're talking calendars with 10, 12, 14 cases, and most of them have children in common, and we are talking about, yes, you need to take the time to talk about custody, talk about parenting time, talk about child support, talk about including all of the detailed exceptions that you need to include, then we are talking a significant amount of time. So getting that buy-in, how are we going to do all this in this limited amount of time? Sustainability and retaining institutional knowledge was also a big one for us. That in part is due to the judicial turnover, but we're a very big system. There's 1.2 million people in Hennepin County, and we probably handle 3,000 civil protective order cases in a year. So there are a lot of spokes in this wheel, and to keep it running, we've got court administration. Their staff comes and goes in addition to the judicial staff. We've got the Domestic Abuse Service Center, which is a separate entity. And so trying to, as we went through and made systems change in both in processes and procedures, how do we retain that was a huge challenge. And again, no uniform approaches to domestic violence cases. We had some judicial officers who thought that if parties were married, then neither parent has a greater right to access to the children than the other. Or if parties wanted financial or custody and parenting time issues addressed, then they needed to go to family court. Well, that ignores the reality that married parties may not be necessarily ready to proceed with divorce. It also ignores the reality that in our family court system, with divorces and custody paternity cases, we employ an early case management system to focus on reducing litigation and focusing on ADR, which overall can be a good thing. However, that does not very adequately address cases or provide relief in cases that there is domestic violence. So that didn't work well either. So we tried a number of things to figure out what to do with all of this information and both change policies, procedures, and philosophies. So one of the first things we did was a judicial survey, a very simple survey monkey, trying to maximize the amount of responses that we get. So for example, we sent out to judicial officers, how often do you address custody and parenting time issues in civil protective orders? And then if they said, if we had another question about the reasons that you don't, and we offered options. I don't have enough time, I don't have enough information, and other. Same thing for providing financial relief. I don't have the information from anyone, I don't have time, I don't know how to use the child support calculator, which we have in our state. So that way we could take the responses and figure out where to focus our training efforts. And then we developed some intensive trainings for judicial officers, for staff, and for our court personnel, the guardians, district court administration staff, again, anyone who touches these cases, because we are part of a big system, and to work well and implement all of the systems changes, we need to have everyone involved. We also utilize the common domestic violence framework. The SAFER approach used to be called the framework before it became SAFER, and we implemented that with all of it's the language that we use with our court system, our business, and our community partners, and working with them help provide consistency in both in our approach and our practices with these cases. We have implemented and used a number of form orders that have really been critical to providing, they address several issues. Judicial consistency is one of them, but also it addresses the time constraints. If we have form orders that have all of the most common and frequently used provisions in them that can then be tailored to a specific case, it provides judicial officers with the options that we want them, or the issues that we want them to think about as they're handling each case, as well as being able to tailor it to a specific case. It has helped a tremendous amount to use that. We utilized pilot programs is another good strategy. We decided one of our big pilot was to try to figure out how to get a handle on better managing these cases. So we decided to break up our civil protective order cases into two calendars. Those where parties had children in common and some kind of hearing was needed or requested, and those that didn't. And for the child-related relief civil protective order calendar, I'll just call it the DR calendar for short because that's what we internally refer to. It's less of a mouthful. But we used 4 out of the 15 judicial officers to initially hear those calendars. The ones that were the most conscientious, the ones that were the most invested in trying to improve what we were doing. And so we piloted that on January 1st of 2016, and we spent 6 months trying to anticipate all of the various challenges, trying to work on some form orders, trying to figure out how we could best roll this out. And we realized from within a month, we had to add another calendar. We only had them 2 days a week. We had to add 3 days. And we spent lots of blood, sweat, and tears that first year, but we learned a tremendous amount. We were able to tweak procedures and policies and all the moving parts before we rolled it out to a larger audience. And then January of 2017, we doubled the number of judicial officers that were hearing those cases from 4 to 7 or 8. And then in January of 2018, we rolled it out to all 15 of us. That, of course, had its own challenges. And, hurting judicial officers is worse than hurting cats. But and we were dealing, again, the same old challenges kept creeping through, the sustainability, the institutional memory, the turnover amongst judicial officers. But we kept at it. It's now no longer a pilot. It's part of the way that we do business. And not only the courts, but users of the courts and business and community partners understand that this is the way that we're doing business. One of the things, Darren mentioned this before, that has been very useful for us is it's one family, one judicial officer approach, and I know that approach is used in different ways across the country. For us, it means that the judicial officer that has heard a civil protective order matter will also hear the family court matter, and vice versa. We were unable to come up with a hard and fast rule or protocol to schedule those cases for court administration because there are such unique circumstances in every case. But the primary way that we do it, the court administration staff has been trained to relate cases in our case information system, and to check with the one court if another case comes in that another judicial officer is handling, and then the two chambers communicate. So it took some time. There were lots of mishaps, but it's much more consistent now, and I think families appreciate it. Parties still have the right of one free removal of a judicial officer. So, for example, if one judicial officer heard the civil protective order case and then the same one gets assigned to the divorce case, they do have the right to remove that judicial officer. But it happens amazingly infrequently, regardless of the outcome of the civil protective order case. So that is reassuring to us that we're doing something right. I'm sorry, I'm going to jump around a little bit. Well, I'll move. So our successes on this calendar is that we now provide financial relief that is allowed by statute, but wasn't consistently provided due to time constraints. And the importance of providing the financial relief for us is that especially if their victim is financially dependent, it removes a significant barrier to safety and to remaining safe and potentially not returning to an unsafe relationship because of the lack of financial support. We also now consistently provide for custody and parenting time arrangements with safety as the primary concern and well-being of both petitioners and the children. We hold the offending parent accountable for his or her abusive behavior, and what that translates into is not only referring perpetrators to domestic violence programming, but following up with a review hearing. Let's return and see if you have done this. And if so, where are you in the process? What have you learned? And then establishing the least restrictive parenting time arrangements, considering the above priorities. And where that fits into the accountability piece is perhaps at the initial hearing, when the protective order is issued before the programming happens, there isn't any parenting time, or the parenting time is supervised or has to occur in the presence of a designated family member. So at the review hearing, when the perpetrator is returning to report on participation in the domestic violence programming, there is also an incentive to, okay, well, maybe I can see my children now, or maybe I can see them unsupervised. Maybe some of the restrictions will be relaxed. And this is one of the successes that is difficult to measure in numbers or statistics, but anecdotally, I can say that we have had significant successes in these cases. Rather than just issuing a civil protective order for 2 years that says can't have any contact or reasonable parenting time, like Darren referred to, we address some of the underlying dynamics, some of the underlying issues, and hopefully this approach will result in a change in behavior, if not for the relationship with the other parent, the relationship with the children. We don't have any illusions that we are going to fix domestic violence or that every perpetrator of domestic violence is suitable for this approach, and that there are perpetrators of domestic violence that may never be safe to be around. However, this approach has produced much better results for families than just issuing the order for a period of 2 years. I'm going to talk a little bit about, we also had a challenge area 3, and that, one of the things that, and that has to do with getting the access to advocacy and legal services. to victims of domestic violence. And so one of the things that I'll go back to some of the strategies that we employed to address that issue. And like I said previously, we engaged our local legal services providers. They now have their own commitment and their own funding to provide a full-time staff person Monday through Friday at our Domestic Abuse Service Center to be available to victims wanting legal advice or representation. We conducted listening sessions, which was a very interesting and informative way to go. When we first got this grant, the court's relationship with the domestic violence service providers and advocacy community was horrific. There was no respect, there was no trust, and it had to do with a lot of circumstances that had happened years prior, but we knew that it existed. We knew that we had to do something about it because we needed that community support to make the changes that we wanted to make. And so we had an initial meeting, invited a number of service providers, and essentially apologized in that meeting. Said, we know we screwed up. We know that we don't have a good relationship. We want to do better, and we're going to do more than just give it lip service. And so we had a number of listening sessions between advocacy agencies and the courts. We probably had about 4 of them over the last 2 or 3 years. The initial, we decided after the initial one that we would break it out into 2 parts. So the initial part of the listening session is where the advocates meet privately with our grant coordinator. And so they're able to talk about issues, concerns that they have, challenges that they see, things that are working, things that are not working. And so they have the ability to put all that information out there. Then the judicial officers come in, and we've had tremendous attendance at these. And it's a listening session, which you can imagine is sometimes hard for judicial officers to do, but it's done. And it has over time become a bit of a dialogue where, because there needs to be that, so that the court can demonstrate that we're hearing what service providers need, what they're observing, and that we are responding to concerns and needs that are raised. And like I said, they have been some of the most informative strategies that we've employed over these years. We have ongoing trainings with business and community partners, and again, that means with the guardians, with custody evaluators, with alternative dispute resolution providers, with attorneys. We have engaged more recently culturally specific domestic violence service providers and agencies, which has been also an enormous eye-opener. I can give you one example, which is we met with a group called Outfront, whose client, who serves the LGBTQ community. And one of the things that came out of the initial meeting was, you know, the petition for an order for protection says the 2 options are male and female. And so a discussion happened, and it was agreed and is now made it into our form petitions for civil protective order to say male, female, non-binary, or other. And it also references pronouns, preferred pronouns, whether it's he, she, hers, he, him, his, or they, them, theirs. So that, which has been tremendous in terms of, one, helping our judicial officers understand the respectful way to refer to someone who may not appear the gender they identify with on paper. It avoids embarrassment and other uncomfortable circumstances when trying to ask in the courtroom or referring to being disrespectful and referring to someone by an inappropriate pronoun. And it also is more inviting. That was one of the things we heard from out front as to why the community they serve is hesitant to seek protection, is because of the fear of discrimination, disrespect, lack of understanding from the courts. So that has been a tremendous source of information for us. We did hire a resource coordinator that I indicated. She currently works half-time, and her position now is to gather resources for the courts to refer parties to, whether it's supervised parenting time programs, domestic violence programming. One of the things that she will do is meet specifically with a respondent who is required to do programming to find the right fit, whether it's a culturally specific program, whether it's a program that in terms of location or cost or time of day that programming is offered, things that the court really cannot do. She's just started with us, and we have high hopes that her position will move from a part-time to a full-time position that is not just grant funded, but again becomes part of the way that we do business. These are some of the successes that we've had. Some of these I've already talked about. The Domestic Violence Advocacy Network is actually a network that came out of our listening sessions with advocates, and they, within the various agencies, have sort of partnered up to share, be a support for each other, pairing up, for example, a less experienced advocate with a more experienced advocate to help them better do their own job independent of the courts. We have developed a firearm surrender protocol. I know we're not really talking about firearms in this webinar, but that is another success that came out of the work that we have been doing. We're kind of running out of time, and I know Darren's got some things to address. These additional slides that are examples of language that are taken directly from our form orders. It addresses both situations. As Darren mentioned, if paternity is not adjudicated or there's not some other establishment of parentage, it provides options for the court to address those issues. So there's some language, examples of custody and parenting time language. This exception is a big one because the exceptions, for example, even attorneys don't think about, okay, we agreed to pay child support, but we have to have a way to pay the child support that's not a violation of the order for protection. How are parties going to communicate about the children, if at all? You have to have a conversation with the parties about that. Is it by email, text, telephone? Is it in emergencies? Is it through a third party? But all of that needs to be very, very specific. And the way to, if you're a judicial officer or an attorney representing a party, I think the way to talk about this is we need to be specific about exceptions so that everyone is safe and so that there's no inadvertent violations. So there's some buy-in from both of the parents there. This is parenting time language. And again, programming or chemical health treatment. And this is the review hearing language that we use. The one thing that I would point out, that ordering review hearings is a kind of a delicate balance. Petitioners usually want to participate in the review hearing because they want to know if anything is being decided about parenting time. Obviously, there's a vested interest, and they may want to know whether the respondent has complied with the programming provision. But there's also weighing that against the re-traumatizing the petitioner, requiring the petitioner to take time off work, drive downtown, pay for parking, take time off work, etc. And so we have added a provision that the petitioner may appear by phone, and that may be something to consider if your courts offer that option. So I think Is that you, Darren?
Yes.
Okay.
Thank you so much, Mary. And that was a lot of really, I think, very practical information that was shared. And so Hennepin County is a court. This is a court that really decided they wanted to improve the civil over the course of the project. That it was a civil protection order process in many ways that needed the most improvement, and took a look at what they were doing and went about in a very collaborative way coming up with improvements. So there's so many lessons to learn from the work that Mary and her colleagues did. I know they're very generous with their time in explaining what their experience was and sharing practical hints. Definitely download the PDF of this webinar so that you can look at that language in more detail, because there are a lot of very practical considerations that went into it that folks often don't think about, as Mary alluded to. And
I will also add, if anybody wants the form orders, please reach out to NCJFCJ. I'm happy to get those out to anybody.
Great, thank you. So we were going to close out by talking about just a couple of other things. I mentioned earlier that we think that one big piece of this to have an effective system is to ensure that there's enforcement. And Mary already touched on one of the big keys to doing so. To the extent that you can schedule review hearings upon issuance of orders that include child-related release, you're really going to go a long way towards ensuring that there's compliance with these orders. And so Mary provides you with an example of the kind of language you can include. We also think that it's a delicate balance in terms of safety and also having the ability to participate for the petitioner. And we've been pushing more and more courts who are thinking about this to allow for telephonic appearance in the way that Mary described. So we really applaud the work and are building on the work in Hennepin County in that area. But we know that it's often a hard sell with judges to do compliance review. I'm currently engaging with more than one community around compliance review, and there's a lot of resistance to the feeling that it takes up too much docket time. We don't have the time and resources to do this work. But we do have some judges who will tell you that it ends up being a net benefit for the court to address things in this way. It can sometimes eliminate the need for folks to have to use a civil contempt process, and it can otherwise assist the court. So it's definitely, if it's something that you are considering in your communities, definitely reach out to us, because we have some ideas and some courts we can point to that are making this work, including Mary's. But if you're not going to use a compliance review process where the court sets a hearing, then it's really important to make sure that the contempt process, which is really the only way in most places to get any sort of enforcement of parenting time type provisions, that it's accessible, understandable for petitioners. And one of the things you can think about doing is providing information sheets to petitioners upon issuance of an order, saying, you have an order. If you have any concern about violation of these provisions, here's what you can do. And of course, for a lot of them, calling 911 and getting law enforcement involved is the best response. But in terms of child-related relief, it may be that you can explain what the person has to do, and that it's probably going to involve filling out some sort of petition or complaint to hold the other party in contempt through the process. So, and folks don't know that and don't understand it generally. Even stakeholders don't understand what that process looks like, and in very few places is it user-friendly. So those are some thoughts around enforcement. We also talked about education, and what we provide here is a set of recommended things to address through training programs around these issues. And we think it's really important for all stakeholders, including judicial officers, so there's a consistent approach to all this, to receive training that hopefully will involve interactive exercises and will be experiential, that address the identification of the nature, context, and effects of abuse and how to account for it in civil protection orders. So application of the SAFER approach is one way to do that. So they learn about child development and how trauma and domestic violence affects it. They can learn about the adverse child experiences, the ACEs, and how it affects folks on a long-term basis, so they understand the reason for doing this and the types of protections that need to be put in place for long-term health of children. and other issues. We suggest also, to the extent possible, make some of these training programs multidisciplinary. And so some of that happened in Hennepin County. Some of it happened in Cook County, Chicago, Illinois, where I did some work in this area with their civil protection order issuing court, where all of the key stakeholders, advocates, attorneys, and judicial officers and others received consistent training programs, complementary training programs around addressing children in civil protection orders, so that the courts knew to look for particular kinds of evidence, and we're seeing it because the advocates and attorneys understood that the court needs to know about the nature, context, and the effects of the abuse. So we strongly recommend that this become a community effort, not just a court effort or not just an advocacy effort or a legal services effort, but that you combine those. We also lay out some specific judicial officer-related topics that are worth including in programs, including what leadership looks like and the fact that you can be a leader in your community as a judge and maintain your neutrality and abide by the canons of judicial ethics, overcoming bias, and vicarious trauma and self-care for attorneys as well, and to help judges think about how they can use their peers for support and mentoring. And also, we would love to see statewide programs that address judicial officers' needs for training and support in this area as well. So some ideas are in the guide that I mentioned earlier around these topics, too, that we think you would benefit from taking a look at. Finally, feedback and refinement, and Mary laid out an excellent way to do this. Listening sessions, especially if judicial officers are willing to listen, hear what the public is thinking of, what your clientele is thinking about court services, that could be an amazing way to get information. We lay out a couple of other ideas on these slides you can take a look at. NCTA, FCTA has a civil protection order guide that's out there as well, available on the website, that has some ideas around evaluation, and also to think about in terms of, in addition to listening sessions, some of the sites that we've worked with have used focus groups, and they talk to victims, they talk to advocates, they talk to victims who engage with the court system regarding their children, and victims who chose not to, and why they chose not to, which can be a great source of information. Surveys and reviewing your dockets to see what happened. How many people are requesting child-related relief, and what's happening? What are the outcomes? Are orders being issued that include child-related relief? Cook County did some of that work as well, and in fact collected a bunch of data and are currently got a research grant to look at it in more detail to see what some changes in their process meant in terms of requests for relief and ultimate outcomes as well. And we're going to see the results of that research in the next couple of years. So we're pretty much out of time, so we're not going to have an opportunity to really have this conversation. But I think that Mary and I and the National Council encourage you to take a look at the document that we mentioned, take a look at the slides and some of the ideas we have, think about what's working in your court and in your community with other stakeholders, what remains challenging for you, are there any ideas from the materials that we provided you that can help you think through some potential solutions. Think of your strengths, think of what is working and how you can build on those strengths in terms of providing better relief for folks who need child-related relief. And we really challenge you to think about what element of the process will you focus on moving forward, hopefully taking the information we've shared with you today. Who will you bring to the table in order to have these conversations and try to think of some ideas, and also to think about how the National Council, Mary and her colleagues, and the rest of us can support your efforts. So we welcome requests for assistance in this area. It's something that the National Council remains committed to helping you with, and we hope that that this overview of the guide that we put together and some of the ideas that we learned in the course of that work and through the Family Court Enhancement Project provide you with some spark and impetus and also some ideas for helping to assess and improve your systems. So before I say goodbye and thank you all, I'll turn it over to Mary to see if she has anything to say.
I don't have anything further. I thank everybody for participating, and again, if there's anything that I can provide in terms of resources from the work that we've done, feel free to reach out. I'm happy to do that.
Thank you, Mary. And we put up on our last slide here is contact information for both the Better Women's Justice Project to develop a safer approach and has lots of other good materials, and the National Council, and how you can get some information from them around some of these issues as well. So thank you so much for spending time with us on this what we think is a very important issue. And we appreciate your ongoing efforts and would love to hear about what you're trying to achieve in your communities. So thank you and good afternoon.
Thank you.
Or good late morning on the West Coast.